I just read the title of this news article and I thought, while I am reading this, let me share my thoughts as candid as possible. So the title said, Supreme Court orders husband to pay 1.25 crores permanent alimony to wife while dissolving marriage. Now I open up the judgment because we do not just believe articles, because judgments give a lot of extra data. So this is first thing that catches my eye is that this is an SLP of 2018, right? And now the judgment goes on to say appeal arises from judgment dated so and so August 2018, so 7 years pending before the Supreme Court. Now the High Court, this SLP is against a judgment by the High Court of Madras when the judgment was passed in 2017. And then the divorce which set aside a decree of divorce granted by the family court in 2016. So almost divorce granted in 2016. Which year was the divorce initiated is now what I wonder. Marriage took place 2009, son born 2010. To 2012, husband instituted divorce, right? Assuming, say, perhaps the husband was aged 30 years. Now he must be, when he initiated divorce, now he must be 43. What is left of your life and how much of resilience do you have left? Anyways, 2012, he initiates divorce. The family court granted divorce in 2016, wife challenged in 2017. The husband contracted a second marriage in 2017. High Court set aside the decree of divorce. It observed that the principal instance of cruelty accepted by the family court was rude utterance of the respondent wife's father. High Court held that while such utterances may have agitated the appellant husband, respondent wife could not be held liable for them. And the Supreme Court mentions that notice was issued to explore the possibility of settlement. Husband instituted an application under Article 142 of the Constitution, I've talked about in other occasions. Evident no possibility of reconciliation, living separately since 2010, since the past 15 years, no vestige of matrimonial relationship between them. Neither party shown any inclination to resolve differences. Appellant husband remarried since 2017, no purpose in continuing the marriage, invoked under Article 142. Now, what is interesting is what was the reasoning of the court to grant alimony of 1.25 crores? Sometimes the court grants 5 lakhs, sometimes 20 lakhs, sometimes 50 lakhs. Now here, 1.25 crores. Further deem it just and proper to award a one-time lump sum permanent alimony to the respondent wife and their son. Brought to attention, appellant husband has not provided any financial support considering the financial status of both the parties and the circumstances of the case. We direct the appellant to pay a sum of rupees 1.25 crore as permanent alimony. The marriage stands dissolved. He shall pay 1.25, 25 lakhs, 5 installments. Any default, the order shall stand recalled, the amount paid be forfeited. So, couple of thoughts. The recent Supreme Court judgment. One takeaway is that we've been seeing in many cases the Supreme Court steps in and tries to dissolve the marriage, especially when it does not see the marriage working out. But, as has been mentioned multiple times, especially by that 5-judge bench, judgment of the Supreme Court dealing with 142 powers, it is going to be done sparingly. It cannot be that you can directly approach the Supreme Court because my case is exceptional. Supreme Court says only if a matter is pending before us that we can exercise our discretion and choose to decide whether we want to pass orders under Article 142 of the Constitution or not. Apart from that, one thing that every husband has to be very careful of when moving an Article 142 Constitution application before the Supreme Court is that you could be hit with any random amount of alimony. When a wife seeks maintenance and alimony in the courts below, at least courts have to go through evidence, courts have to go through the financial status of the parties, the Supreme, and if they pass an erroneous order, there are courts sitting in appeal. There's the Sessions Court, there's the High Court, there's the Supreme Court of India. However, when the Supreme Court fixes any alimony amount, you could be dead broke and not having a single bit. And then the Supreme Court says, we exercise in our wisdom, you have to pay 50 lakh rupees as permanent alimony. I would call it a death sentence. What else could it be? So you have to be very careful. And if you are moving an Article 142, like we're doing for this one client, while we are doing this 142, you must also file on record all of your assets and your income so that the court can make a just decision. Obviously, you don't want the court order to bleed you dry, but you don't want it to be based on assumptions, because obviously, if you're the husband, the wife is definitely going to say that my husband is richer than all the billionaires in the world put together. But you have to put the right facts in front of the court so as to have not a fatal order against you of the alimony amount. Apart from that, a lot of husbands ask me, how do I get this thing done? I desperately want to get this divorce as soon as possible. The Supreme Court has made it clear you cannot be coming to us directly. So what are your options? One is you as soon as possible, in as hurried fashion as possible, move your applications, petitions. What are some things can be done? For example, you move a perjury against the wife for not disclosing everything. Trial court dismisses early hearing of that perjury. The High Court dismisses, you appeal it before the Supreme Court. Boom, you've got your case. Even simpler is a transfer petition moved either by the husband or by the wife. If just notice is issued by the Supreme Court, you are good to go. Now you've got the opportunity to move an Article 142 petition while a transfer petition is pending in the Supreme Court, even if your wife has instituted that transfer petition. Now, obviously, the Supreme Court will very often refer the matter to mediation. A lot of times we've seen results come out in the mediation itself, especially when given a little extra push by the Honorable Supreme Court as well. If mediation is unsuccessful for whatever reason, you can move an application under Article 142. In fact, let me tell you, one of our cases, I am very sure that we availed of our civil and criminal remedies in law against the wife. And the wife is deliberately, and we did it in another jurisdiction, very far away from the jurisdiction where both parties are fighting all the other cases filed by the wife. But we know the only reason why the wife is not moving a transfer petition before the Supreme Court is that she knows the moment she does this, we will move an Article 142, because this particular case is a very fit one for immediate grant of divorce. And she does not want divorce. And here is also a case where the husband says, I'm ready to pay a very large sum, in fact, larger than this permanent alimony sum. He's ready to give, but she wants far more. And so that is the reason why she's not moving a transfer petition, has actually hired lawyers. In fact, not in one, not in two, 3 different jurisdictions where the husband has availed of his legal remedies, civil and criminal. It is incredible, the lengths at which parties go to avoid the Supreme Court sometimes. Very interesting. Anything else that comes to my mind, perhaps I'll share it in the comments below, but thank you for bearing with me for so long.